In this part 30, after discussing right from section 154 up to 176 of the Criminal Procedure Code, dealing with information to the police and their power to investigate, we now intend to start discussing provisions of jurisdiction of the criminal courts in inquiries and trial. We will try to understand the territorial or local jurisdiction as compared to that of civil procedure code, where we have to take into consideration what do you mean by pecuniary jurisdiction, what do you mean by exclusive jurisdiction depending upon the subject matter, depending upon where the property is situated. Here, as far as criminal law is concerned, there is only one type of jurisdiction, and that is what is known as local or territorial jurisdiction. And that is made clear as far as the first section, namely section 177 of the Criminal Procedure Code is concerned, which says, every offence shall ordinarily be inquired into and tried by the court within whose local jurisdiction it was committed. So this is the principle. The offence shall be tried only by that court within whose local jurisdiction it was committed, as far as section 177 is concerned, which lays down the basic principle from the point of view of administration of criminal justice. Now, if the court which had no jurisdiction has dealt with the case, what is the effect of it is dealt as far as section 462 of the Criminal Procedure Code is concerned. And to understand section 462 of the Criminal Procedure Code, you have to refresh your memory as far as right from section 460 up to 466 of the Criminal Procedure Code, which deals with what do you mean by irregular proceedings. Section 462 deals with proceedings in a wrong place, and it says, no findings, sentence or order of any criminal court shall be set aside merely on the ground that the inquiry, trial or other proceedings in the course of which it was arrived at or passed took place in a wrong sessions division, district or subdivision or other local area, unless it appears that such error has in fact occasioned a failure of justice, otherwise not. So if the result is that of failure, if it has occasioned a failure of justice, then only, otherwise this is dealt as far as wrong place. If the inquiry or the trial has taken place, what is the effect of it is dealt as far as section 462 of the Criminal Procedure Code is concerned. Now, though section 177 says every offence shall ordinarily be inquired into and tried by the court within whose local jurisdiction it was committed, this ambit of the jurisdiction has been enlarged. And then it is not only one court only which has got jurisdiction, but right from section 178 up to section 184 and then section 188 are the exceptions to this general rule laid down by section 178. And then any one of the court may have jurisdiction to deal with a particular offence, as if at all it falls under right from section 177 up to section 184 and then 188 of the Criminal Procedure Code. Now this is a question of enumeration. If the case falls under any one of the exceptions, then only any one of the court has got jurisdiction, and hence the time for us to go through right from section 177 onwards of the Criminal Procedure Code. 178 says place of inquiry or trial, and it says when it is uncertain in which of several local areas an offence was committed, that is first category, or where an offence is committed partly in one local area and partly in another, or thirdly, where an offence is continuing one and continues to be committed in more local areas than one, or where it consists of several acts done in different local areas, it may be inquired into or tried by a court having jurisdiction over any of such local areas. So, four exceptions to section 178, small a, small b, small c and small d are enumerated as far as section 178 is concerned. Now, offence triable where act is done or the consequence ensues is made very clear as far as section 179 is concerned, which says where an act is an offence by reason of anything which has been done and of consequence which has been ensured, the offence may be inquired into and tried by a court within whose local jurisdiction such thing has been done or such consequence has ensured. So where the thing is done or where the consequence has ensured, any one of the court may have jurisdiction as far as section 179 of the Criminal Procedure Code is concerned. Now section 100 deals with the cases which says place of trial where act is an offence by reason of relation to other offence, and it says when an act is an offence by reason of its relation to any other act which is also an offence, or which would be an offence if the doer were capable of committing an offence, the first mentioned offence may be inquired into or tried by a court within whose local jurisdiction either act was done. So that is as far as section 180 of the Criminal Procedure Code, whereas section 181 has laid down 5 subclauses because of which 5 exceptions are laid down, and then place of trial in case of certain offences is laid down as far as section 181 is concerned. Firstly, it says any offence of being a thug or murder committed by a thug, of dacoity with murder, of belonging to a gang of dacoits, or of escaping from custody may be inquired into or tried by a court within whose local jurisdiction the offence was committed or the accused person is found. So where the offence was committed or where the accused person was found has, as far as subclause 1 of section 181 is concerned. Secondly, it says any offence of kidnapping or abduction of a person may be inquired into or tried by a court within whose local jurisdiction the person was kidnapped or abducted or was conveyed or was concealed or was detained. So where the person was detained, where the person was concealed, where he was conveyed or abducted or kidnapped, any one of the court has got jurisdiction. Thirdly, it says any offence of theft, extortion or robbery may be inquired into or tried by a court within whose local jurisdiction the offence was committed, or the stolen property which is the subject of offence may be possessed by any person committing it or by any person who received or retained such property knowing or having reason to believe to be stolen property. And then the fourth clause as far as section 181 is concerned lays down any offence of criminal misappropriation or of criminal breach of trust may be inquired into or tried by a court within whose local jurisdiction the offence was committed, or any part of the property which is the subject of the offence was received or retained or was required to be returned or accounted for by the accused person. And lastly, this section 181 says any offence which includes the possession of stolen property may be inquired into or tried by a court within whose local jurisdiction the offence was committed or the stolen property was possessed by any person who received or retained it knowing or having reason to believe to be stolen property. And then now as you go on understanding criminal procedure code, this is the time again for you to refresh your memory as far as understanding of the refreshing of Indian Penal Code is concerned. So when you want to know if this section which deals with one of the clauses deals with stolen property, what do you mean by stolen property? You should again have you should immediately have reference to section 410 of the Indian Penal Code, which defines what do you mean by stolen property, whereas right from section 411 up to section 414 are the sections which deal with receiving or returning stolen property which is made punishable. So as you go on reading the section which is enumerated as far as or to which we come across at the time of dealing with the provisions of the Criminal Procedure Code, the time for you that you must know the offence, then only it will be possible for you to understand the provisions with which we are dealing as far as Criminal Procedure Code is concerned. With this now, section 182 deals with offences committed by letters, etc. And it says, any offence which includes cheating may, if the deception is practiced by means of letters or telecommunication messages, be inquired into or tried by the court within whose local jurisdiction such letters or messages were sent or were received, and any offence of cheating and dishonestly inducing delivery of property may be inquired into or tried by a court within whose local jurisdiction the property was delivered by the person deceived or was received by the accused person. So this any one of the court has got jurisdiction as far as when the offence is committed by letters, from where the letter is written, from where the letter is written, for where the letter is received, or where the act which is required to be done as per the letter, which amounts to an offence, is done on the part of an individual, is dealt as far as subclause 1 of section 182 is concerned. Subclause 2 deals with the offence of bigamy, namely marrying during the lifetime of either spouse, along with section 495, which is an aggravated form of 494. It says, any offence punishable under section 494 or section 495 of the Indian Penal Code may be inquired into or tried by a court within whose local jurisdiction the offence was committed, or the offender last resided with his or her spouse by the first marriage, or the wife by the first marriage has taken up permanent residence after the commission of the offence. So, which is the court that has got jurisdiction? Not only one court, but any one of the court has got jurisdiction, and hence that is an exception to the principle which is laid down as far as section 177 is concerned, which says every offence shall ordinarily be inquired into and tried by the court within whose local jurisdiction it was committed. Now there may be cases where the offences are committed on journey or voyage, and the section 183 says, when an offence is committed which the person by or against whom or the thing in respect of which the offence is committed is in the course of performing a journey or voyage, the offence may be inquired into or tried by the court through or into whose local jurisdiction that person or thing is passed in the course of that journey or voyage. So that is as far as section 182 is concerned, which have 183 of the Criminal Procedure Code is concerned. With this now, the next section, namely section 184, deals with place of trial for offences triable together. And it says, where of the offences committed by any persons are such that he may be charged with and tried at one trial for each of such offence by virtue of the provisions of section 219, section 220 or section 221, or b. the offences or offences committed by several persons are such that they may be charged with and tried together by virtue of the provisions of section 223, the offences may be inquired into or tried by the court competent to inquire into or try any of the offences. Now this section can be understood by us provided we understand what do you mean by jointer of charges. We shall be dealing with charge right from section 211 up to section 224 of the Criminal Procedure Code during course of our lecture. And then when we will try to understand what do you mean by jointer of charges, there which is an exception to the principle which is laid down as far as section 218 of the Criminal Procedure Code is concerned, which says for every distinct offence which the person is accused, there shall be a separate charge and every such charge shall be tried separately, to which we shall be dealing with the exceptions as we deal with that particular chapter, and you will understand importance of this section, namely section 184 of the Criminal Procedure Code at the time when we discuss the provisions as far as jointer of charges is concerned, to which we will again have reference as far as section 219 is concerned, or section 220 is concerned, or section 221 is concerned, or section 223 with which this section, namely 184 of the Criminal Procedure Code deals. With this now, if the offence is such, when the offence is committed outside India, whether the Indian Penal Code is applicable when the offence is committed beyond the territorial limits of India, is made very clear as far as the first chapter of the Indian Penal Code is concerned, which deals with intra-territorial and extra-territorial operation of the Indian Penal Code. Indian Penal Code is applicable to every person who commits an act within the territory of India. But Indian Penal Code is also applicable if the offence is committed beyond the territorial limits of India, for which you have to read section 3 along with section 4 as far as the Indian Penal Code is concerned, which speaks about application of the Indian Penal Code beyond the territorial limits of India. And if the Indian Penal Code is applicable, which is the court that has got jurisdiction, is made very clear as far as this section, namely section 188 of the Criminal Procedure Code is concerned. And this section says, when an offence is committed outside India by a citizen of India, whether on high seas or elsewhere, or by a person not being such citizen on any ship or aircraft registered in India, he may be dealt with in respect of such offence as if it had been committed at any place within India at which he may be found. So that is the court which has got jurisdiction as far as section 188 is concerned, subject to proviso. And it says provided that notwithstanding anything in any one of the preceding sections of this chapter, no such offence shall be inquired into or tried in India except with the previous sanction of the central government. So this is, there must be a sanction of the central government in order to try him for the offence, which is triable, no doubt about it, but which is triable within India, though it has taken place beyond the territorial limits of India, as far as section 188 of the Criminal Procedure Code is concerned. And then when you talk about evidence, as far as that offence is concerned, that is made very clear as far as section 189 of the Criminal Procedure Code is concerned, which says, when any offence alleged to have been committed in a territory outside India is being inquired into or tried under the provisions of section 188, the central government may, if it thinks fit, direct that copies of depositions made or exhibits produced before a judicial officer in or for that territory or before diplomatic or consular representative of India in or for that territory shall be received or as evidence by the court holding such inquiry or trial in any case in which such court might issue a commission for taking evidence as to the matters to which such depositions or exhibits relate. So this is receipt of evidence relating to the offence committed outside India, which is dealt as far as section 189 of the Criminal Procedure Code is concerned. With this now, though this we have dealt with section 177 and then we have dealt with the exceptions to it. Section 185 speaks about power to order cases to be tried in different sessions division, and it says, notwithstanding anything contained in the preceding provisions of this chapter, the state government may direct that any cases or class of cases committed for trial in any district may be tried in any sessions division, provided that such direction is not repugnant to any direction previously issued by High Court or the Supreme Court under the Constitution or under this code or any other law for the timing in concern. So this is the power that vests in the state government as far as the trial with respect to particular type of a cases is concerned is dealt as far as section 185 of the Criminal Procedure Code is concerned. Now, there may be a situation where cognizance of an offence is taken directly by two courts, and which court should deal with it is dealt as far as section 186 is concerned, which says, where two or more courts have taken cognizance of an offence and a question arises as to which of them ought to inquire into or try that offence, the question shall be decided by 1. If the courts are subordinate to the same High Court, by that High Court, or if the courts are not subordinate to the same High Court, by High Court within the local limits of whose appellate criminal jurisdiction the proceedings were first commenced, and thereupon all other proceedings in respect of that offence shall be discontinued. So this is as far as section 186, which deals with the situation where cognizance of an offence is taken by two courts, which is the court that has got jurisdiction as far as Criminal Procedure Code is concerned, is made very clear as far as this section of the Criminal Procedure Code is concerned. So this is regarding jurisdiction of a criminal court, which, as we have already understood, deals with the local or territorial jurisdiction of the criminal courts accordingly. With this now, we intend to start with the next chapter, and the next chapter deals with the power to take, or what do you mean by taking cognizance of an offence. And if we read the chapter right from section 190 up to 199 of the Criminal Procedure Code, we will try to understand as to what do you mean by taking cognizance of an offence. But then this is a time where if you read the heading of the chapter that deals with conditions requisite for initiation of proceedings, and then section 190 of the Criminal Procedure Code merely lays down the ways in which cognizance of an offence may be taken by the court of magistrate. But then what do you mean by taking cognizance of an offence is nowhere defined in the Criminal Procedure Code. But this is exactly the stage at which magistrate has taken judicial notice. The stage at which magistrate has determined, the stage at which magistrate has decided, the stage at which magistrate has determined or made up his mind to proceed further, or he has taken judicial notice. There is no formal action, but the point of time at which one can come to the conclusion as to the magistrate has decided to proceed further as per the provisions of the Criminal Procedure Code with respect to that offence is exactly the stage at which it can be said cognizance of an offence is taken by the magistrate. The first court that comes into picture as far as the provisions of the Criminal Procedure Code is concerned is the Court of Magistrate. And then the trial may be by any one of the courts as enumerated by a last vertical column of the first schedule of the Criminal Procedure Code. So offence may be triable by court of session. There can be trial before a court of session, right from section 225 up to section 237. But the cognizance of an offence is taken by the court of magistrate and not by the court of session. There is only one exception which is laid down as far as this chapter is concerned, where the sessions court directly comes into picture. And for that as we will deal with this chapter, we will come across section 199 subclause 2, where cognizance of an offence is taken by the court of session. Otherwise, cognizance of an offence, and it is cognizance of an offence is taken as far as the magistrate is concerned, and then the ways are enumerated as far as section 190 of the Criminal Procedure Code is concerned. It says, subject to the provisions of this chapter, the magistrate of the first class and by any magistrate of the second class specially empowered in this behalf under subsection 2 may take cognizance of any offence. A. Upon receiving a complaint of facts which constitute such offence. B. Upon a police report of such facts. And C. Upon information received from any person other than police officer or upon his knowledge that such offence has been committed. The Chief Judicial Magistrate may empower any magistrate of the second class to take cognizance under subsection 1 of such offences as are within his competence to inquire into or try. So, this section enumerates the ways in which cognizance of an offence may be taken by the court of magistrate as far as small a, small b or small c of subclause 1 of this section, section 190 of the Criminal Procedure Code is concerned. Somebody directly goes to the magistrate and complains to the magistrate as it is defined by section 2d, which says complaint is an allegation which is made orally or in writing to the court of magistrate with a view that he should take action that some person, whether known or unknown, has committed an offence. Yes. Or when the investigating officer has completed his investigation and submitted report as per subclause 2 of section 173 of the Criminal Procedure Code. Or magistrate has received, upon information which is received from any person other than police officer or upon his own knowledge are the ways that are enumerated as far as section 190 is concerned. Now, if it happens that magistrate has taken cognizance as far as small c of subclause 1 of section 190 is concerned, namely, upon information which is received from any person other than police officer or upon his own knowledge, then magistrate has to follow the procedure which is laid down as far as section 191 is concerned. We say, when a magistrate takes cognizance of an offence under clause C of subsection 1 of section 190, the accused shall, before any evidence is taken, be informed that he is entitled to have the case inquired into and tried by another magistrate, and if the accused or any of the accused, if there be more than one, objects to further proceeding before the magistrate taking cognizance, the case shall be transferred to such other magistrate as may be specified by the Chief Judicial Magistrate in this behalf, with the object of observing the principles of natural justice and during course when we shall be dealing with trial or understanding criminal procedure code, we will come across many principles of natural justice, and the one is that the judge should not be interested in a particular case, and hence this is when he has received upon his knowledge or when he has received information from any person other than police officer, he is likely to be interested, and hence the case is required to be transferred to some other magistrate. Whereas section 192 says any chief judicial magistrate may, after taking cognizance of an offence, make over the case for inquiry or trial to any competent magistrate subordinate to him. Now it also says any magistrate of the first class empowered in this behalf by the chief judicial magistrate may, after taking cognizance of an offence, make over the case for inquiry or trial to such other competent magistrate as the chief judicial magistrate may by general or special order specify, and thereupon such magistrate may hold the inquiry or the trial. Now this is the time for us to understand importance of section 193. This says cognizance of offences by court of sessions, and it says except as otherwise expressly provided by this code or any other law for the timing in course, no court of session shall take cognizance of any offence as a court of original jurisdiction unless the case has been committed to it by magistrate under this code. So cognizance by the court of session is not directly taken, but it is case is committed to the court of session for the purpose of trial, with which we shall be dealing when we start discussing trial before a court of session. Well, we will try to understand the importance of section 209, as per which the case is committed to the court of session for the purpose of trial after taking cognizance of an offence. Now, additional and assistant session judges to try cases made over to them is made clear as far as section 194 is concerned, and it says additional session judge or assistant session judge shall try such cases as the session judge of the division may by general or special order make over to him for trial, as the High Court may by special order direct him to trial. And now, though we say that this is the ways are enumerated or by section 190, and cognizance of an offence may be taken by the court of magistrate, to this general rule, there are in general rule that we have learnt when we try to understand the provisions of setting criminal law into motion, where you have learned anybody can set criminal law into motion. But now, as we start learning right from section 195 up to 199 of the Criminal Procedure Code, these are the statutory restrictions which are laid down with respect to the power of the court to take cognizance of an offence, and it's mandatory, and it says no court shall take cognizance. So the court shall not take cognizance unless there is a complaint on the part of the aggrieved person, unless there is a sanction of the concerned government, or who can be the complainant is made very clear right from section 195 up to section 199, which is a question of enumeration. So during the course of our next lecture, we shall be dealing as far as right from section 195 to 199 of the Criminal Procedure Code, dealing with the provisions, namely the exceptions to the general rule as to the statutory restrictions which are laid down, that anybody can set criminal law into motion unless cognizance of an offence is taken by the court the question of proceeding further doesn't arise. So taking cognizance of an offence is the first and the foremost stage or step as far as the criminal procedure code is concerned, and when it shall be taken by the court of law and when it shall not be taken by the court of law is made very clear as far as this part of the chapter with which we intend to do. Now, along with this chapter, this is a time that when we try to understand conditions requisite for initiation of proceedings, it is also necessary for us to correlate this chapter, and this is what is meant by taking cognizance of an offence. And then when we will start discussing along with this chapter right from section 467 up to section 473 of the Criminal Procedure Code, this is a chapter which deals with limitations for taking cognizance of an offence, and that when we will deal with this chapter we will learn no court shall take cognizance of an offence after expiry of the period of limitation. So there is a limitation which has been laid down. The cognizance must be taken within that stipulated period with which we shall be dealing when we deal with this chapter. So the two chapters, namely right from section 190 up to 199 and then 467 up to section 473 of the Criminal Procedure Code, are required to be clubbed together from the point of view of understanding the provisions as far as taking cognizance of an offence is concerned, and rest of the details with which we will continue our discussion as far as our next part of the lecture is concerned.